that correct?
So, Your Honor, counsel and I have been emailing.
Okay.
So, yes, I think it's appropriate to strike it at this juncture. One, counsel had asked for that because she's just trying to get up to speed. Two, it's my understanding that Mr. Prahl's back on a boat in Alaska again. And at least historically, I understood that he would typically be on the boat until December or January. So I guess as far as timing, also my client had, even though I'm representing her, filed a contempt motion, which the court signed an order to show cause for next week, October 8th, and
Okay.
that has not been properly served. I found out about that, I think, last week while I was out of town. And
Okay.
so I need to cure that issue as well. So I guess my inclination would be that we strike today, we strike October 8th,
Okay.
and then counsel and I can see about either reassigning a date so that I can get notice to her client through her on the contempt issues and she can get up to speed.
And Ms. Dowd, does that work for you?
Yes, Your Honor, that seems reasonable. My client and I have kind of set up a means of checking in with each other. He is fishing out of Dutch Harbor, Alaska. So
Okay.
sometimes he has access to electronic communications, sometimes not. So I think we're going to have a little better contact than he had in the past, but he's still not going to be back here for parenting time for a while.
Okay. So with all of that understood, we'll strike today, and then I'll just check with the clerk. Can I go ahead and strike October 8th as well for this case? Okay, perfect. So that's off for next week as well. So anything else on the Nelson v. Prahl matter?
No.
I don't believe so, Your Honor. Thank you.
Thank you very much.
Thank you. Requesting a set over for presentation with Judge Basher.
Yes, that's correct, Your Honor. We're on the Everdale matter, and I believe Ms. Powers is also on that.
I am, Your Honor. Do you know when Judge Basher will be back on the docket?
Yeah, no, it'll still be me next Tuesday, but he'll be back Tuesday, October 15.
If we could set over to that date.
Okay. So I'll have the clerk go ahead and set over presentation on the Everdale number 7 on our docket.
I'm actually in trial. I'm actually in trial that day. I can try to get out if that's okay with everybody, but otherwise I'm in trial in Wakayakum.
How, Ms. Powers, I guess your preference on trying to make that work, and then if not bumping it, or do we just want to set for the 22nd?
I'm pulling up my calendar right now. I know I've got a 3-day trial set.
Okay.
And it's set for the week of October 21st. So that makes me a little nervous.
Okay.
But maybe let's go for the 22nd. I know Wakayakum is a little harder to juggle than if my trial's in Cowlitz. So let's set it for the 22nd, and I will make it work if my trial goes.
Okay.
And I appreciate that.
Okay. We'll go ahead and set this matter then to October 22nd, not the 15th, for Judge Basher.
Yes, that matter's
All right.
ready.
Thank you, Your Honor.
Okay.
And we do have Mr. Bagaweson with us as well.
Thank you, Bagaweson. I always say it wrong every time it comes in front of me, and then I hear you say it, and I vow to do better next time. So my apologies to the parties.
No problem.
Go ahead. I have this on for compliance review.
Yes, so you'll see that there's a cover sheet and a calculation sheet. And so there was substantial payments made, which is great. And we really appreciate that. We put those together, those payments together, along with calculations on the interest, as well as the kind of showing the underlying judgments. So in this case, what we show is there's still just over 2,600 left. Still due and owing in child support. There's about 1,300 on the property judgment still due and owing, and there's about 6,300 on attorney fees. We ran interest. This is just interest through August 31st. And you can see that in the calculations. So all told, with those amounts combined, there's total amounts due at this point of $10,259.90. Again, running interest through that August 31st date. if Mr. Bagawisen can get that paid off quickly, we're fine to just cap the interest at that level and not continue calculating interest. Again, assuming that he gets that just last remaining part taken care of, and then we can issue satisfactions for the whole amount.
Okay.
They did get the property transfer completed, which is great. What I have on one of the other remaining issues is there was a timeshare, and there needed to be efforts to get that transferred into his name and the debt into his name. The only thing I have from him is sort of a piece of an email, and it looks like he just sort of emailed the timeshare company. And it's certainly going to take more than that to get that transferred over. And so I need to see more than that to show efforts, true efforts on getting her removed, since that was a negotiated term in this case. My client certainly doesn't have access to that. And so we're just asking that he show efforts, continued efforts to do that, move through the processes to get her removed, to actually effectuate her being removed from access as well as from the debt.
Michael, so let me just ask you this to start out with. Are you in agreement, or do you dispute the amount of money that they've listed as remaining due when you calculate fees, sanctions, and interest?
When I made the payment for the child support and spousal support, they gave me the exact amount that was current, and that's what I paid. So I'm going to have to call and check with them, but they gave me the exact amount. Trying to remember the gal's name.
Well, I'm guessing that may be the base amount for the judgment, but there is interest that was listed in the judgment order. So
I did add that interest.
You did?
Yes.
Okay. Let's circle back to this in a minute. So it sounds like you are disputing that there's still money due and owing. Are you contending that you've paid in full?
I did. And then the interest that was listed in the court papers, I added that to the child support.
Okay. What about the timeshare transaction?
The timeshare, they said it would take up 10 weeks.
Okay.
Now, I can email them and have them send something back.
Okay. So I guess Ms. Baldwin, it sounds like he is contending no further payments due. What would you like to do at this point?
Well, I appreciate that. We've actually shown our work and shown all of the calculations, shown here's each of the judgments, provided proof of the judgment, and the tracking behind. So that it's not just a sheet of paper, it's the sheet of paper with the clerk's paper number on it, and then behind it's actually kind of showing all of that work. As well as what the exact interest amount is. He's just saying, hey, I paid it. And we provided exactly what he paid. So I appreciate his statements. He needs to do, if he disputes the math, he needs to show his own math. The Division of Child Support historically has never calculated interest. I've never seen any of their materials calculate interest whatsoever. And that's true for both spousal support and child support. They just don't calculate it. It's not part of their system. They consider that to not be something that they have an interest in. They just have an interest in the base amount. So my guess is that if he asked them for the amount, it did not have the interest calculation as part of it. And on the issue of the timeshare, the court has to keep in mind that the final orders in this case were entered back in April. So 10 weeks, has certainly gone and passed. We've subsequently held him in contempt back in August. So August, we've had August, September, we're now moving into October. So I don't have any issue with setting this matter out a few more weeks for him. But then my request would be that he needs to, if he's disputing the amount, he needs to do a filing that shows his own math, so that then we can apples to apples comparison. And he needs to then provide proof that he's done more than just simply email the timeshare company, because that's all I've seen him do at this point. That's all he's provided proof to me that he's done.
So, sir, what I did review their compound and simple interest calculator forms on the back of their filing. The judgment from April does indicate that child support, medical support, child expenses would accrue at a 12% yearly interest rate. There was also an interest rate for attorney fees. So at this point, what I have in front of me does support their request for the additional monies owed. So I'm going to give you two options. You can agree. You haven't filed anything, so I have nothing else to go on, but you can agree that that's the total amount due. We can set this out 30 days to review for compliance. Or if you really are contesting the base amount, I would probably set this out 2 or 3 weeks if you want to submit any documents that you think support that these amounts are incorrect.
Yeah, I'd like to set it up because, like I was saying, I called the child support office and got the exact amount
Okay.
just before we went into court. I paid the exact amount that was due to the child support, and then the interest that was listed in the court papers, I paid directly to Clover. I included it in the payment that was supposed to go to her.
So so let me ask you both this. I will be back on this docket next Tuesday. And since I'm the one that needs to review this, that would be easiest for me. I don't know if you can get it filed that quickly, or I could set this for 2 weeks out to October 15th. I'll just have to step on after Judge Basher does his docket or before.
I'm available next week.
Can we go 2 weeks? Because every Tuesday that we have court, I have to miss my court-directed class that I'm supposed to be at. So they've listed me as non-compliance there, but I'm here. So I'd like to make a class, and I have to explain to the other court, Pierce County, that I've been.
Sure, but sir, this could have been avoided by you submitting objections in writing today. So instead of you being inconvenienced, you're asking the court to inconvenience themselves and set it out 2 weeks instead of a week.
If it can't be done, then it can't be done. That's fine. And as far as the timeshare thing, I had taken her off everything, and then I called right before, I think it was August 27th court. I called and I said, is she off the credit card? Yes. Is she off the account to where she can book? Yes, you did that like 2 years ago. I said, is she anywhere on this account? And they said, she's on the title. And I did not realize that. And that's the part that I showed Miss Baldwin, where I emailed the company and gave all the information, did what they said to have her removed.
Yeah. Okay, I'll set this out 2 weeks. My hope is that 2 weeks, well, not my hope, my requirement at 2 weeks is you will have already filed with the court and served on Ms. Baldwin's office your support for the numbers that you believe are correct. So that needs to have supporting documentation with it. And then I would like to see some further progress on the timeshare, perhaps response back in writing from the timeshare company that yes, she is removed, something like that. Okay.
I'm going to ask that he have that filed by October 9th, just with the idea that if he files it by the 9th, it'll hopefully actually appear in Odyssey for your honor to be able to see it.
Yeah. I will set October 9th as the filing deadline for that. So that gives you a little over a week to get that done. Okay. And then we'll have you back on the 15th at 1 o'clock. Okay. Anything else on this matter?
No, Your Honor.
Okay.
No, ma'am.
All right. Thank you so much. We'll see you back in 2 weeks.
Thank you.
Michael Begaweeson, can you hear the court?
Yes.
Okay. Thank you. So I have us on for compliance review. When we were together last, there was Mr. Begaweeson, you had made a significant payment, but we were still waiting on, I think you had disputed Ms. Baldwin's calculation of the final amount due. I gave you some additional time to submit your calculations and objections because I didn't have anything from you. I still don't have anything from you. I guess I'll turn it over to the parties to see where we're at today.
So we're really in a similar position. So we provided our calculation when with our last filing that showed about just over $10,000 was still due and owing, and that was just with running interest through the summer. So we didn't we sort of gave him credit to some degree and didn't continue to run interest, even though there's an amount still owing. The court set it over about 2 weeks, just over 2 weeks, to give Mr. Bagawiesen additional time to file his response. And along with that is he was supposed to provide an update on sort of his efforts to remove my client from the timeshare obligation. He says a lot regarding that, but hasn't really provided much of anything. And we're really in a similar position. So he provided me a calculation, but I disagree. And it doesn't look like he doesn't provide the tracking or the interest calculations of how he sort of gets from A to B. And he doesn't provide, and it doesn't look like he's provided that to the court. So again, that would be my concern, is he's not providing that to the court either. As to the timeshare issue, he just keeps sending me sort of the same, well, here's an email I shot off to sort of the parent company. Like, well, that's all well and good. But that's not evidence that she's been removed from the obligation. And so that's what I'm looking for, is that she's been removed from the obligation, that she's been removed from the title. You know, his email to sort of the great beyond of Timeshare Co. is not evidence that she's actually been removed from the debt. And so I'm really lacking on both of those issues, and he hasn't provided a stitch more data to the court since the last time we were here.
Most of these people are listed.
Mr. Bagawiesen, let me ask you, kind of taking these issues one by one. Are you still disputing the amount Ms. Baldwin lists as due and owing?
Yes, I sent the paperwork to you.
I have nothing from you. I asked my judicial assistant to check again this morning. We've received nothing. I don't know when you filed it, but I don't have it.
I sent it on the same day I sent it to Miss Baldwin. But I sent it through the mail.
Okay. And if it's not received by the court about at least 3 to 4 days before hearing, I'm not going to have it. It takes a while to get scanned into our system. So I'll circle back to this. Second question is, were you able, what I had asked last time was maybe to have the timeshare ownership folks confirm that she's been removed. Were you able to get that?
I called them and they said it's still in process. They don't send updated where they're at on it. And I said, well, the only email that you sent me was where I had to click on the link to put the information in. I said, that's the only email that I received from you guys. Well, that's considered the confirmation email. I said, well, I need a confirmation email from the court. We don't do that.
Okay. Well, here's what I'm going to do.
They said they have received it and they're processing it.
Okay. I need to receive your documents. What we're going to do is set one final hearing so I can receive your position on the calculations, and then I will issue a ruling. Also, whatever new date I'm setting for you, I'm going to make a decision about whether you're in compliance with the timeshare obligation as well. What we're going to do for this case, since these are the only two outstanding issues, is set this instead, if we could, to a commissioner presentation docket instead of family law B. And if other folks who don't have hearings yet could stay muted, that would be very helpful. So Ms. Baldwin, Mr. Bagawiesen, what I'd be looking at is a Tuesday at 1 or a Friday at 1.
Can we do a Friday?
Yeah, Friday's my preference as well.
Okay. So except for this Friday, the 18th, I do tentatively have a trial that date. I could do Friday, October 25th at 1 o'clock.
That's fine for me.
Okay.
Will that work, sir?
Yes, ma'am.
Okay. And Mr. Bagawiesen, if you get something regarding the timeshare and it's pretty close in time to our hearing date, go ahead and file with the court, but also get a bench copy to my judicial assistant so I can review it before that date. Okay.
Okay.
All right. Anything else the parties need from me? Otherwise, I'll have you back Friday, October 25th at 1 o'clock.
No, Your Honor, that's it for today.
Mr. Vega, we send anything else?
No, ma'am.
Okay, thank you.
Thank
All
you.
right, Judge Basher, I will log off. Ms. Bliss, are
All
you
right,
in the
thank you.
middle of dockets?
I'm here for.
Okay, okay. All right, and I have Ms. Turnbull with us. Mr. Ruby, can you hear us?
Yes, ma'am.
Okay. Oh, they are updated. Okay. Just looking at some documents that just got filed. These appear to be the most recent UAs for Ms. Granzo Carranza showing negative normal UA results. Mr. Ruby, are you aware of those?
No, I'm not.
Okay. Give me just a second here to get, I also have the temporary order that Ms. Granzo Carranza is asking for from this court. So back on August 12th, ma'am, you filed for temporary family law orders in this case. I have those with me, those proposals. And I guess, Mr. Ruby, have you had a chance to review the proposed temporary orders?
A little bit, not a lot. I've been working a lot, so I haven't had a lot of time to work, like 6 days a week. I'm actually currently at work at the moment. So I haven't really had a whole lot of time to sit down because I get home late and I'm up early. So I haven't really had a whole lot of time.
Okay.
I've kind of skimmed through them, yes.
Okay. Do you know, and I'll look back, I guess I have a couple questions. Number one, how did you all end up on the represented docket? So
I'm not 100% sure. Like, we finished all a couple months ago and everything was set. She was supposed to do supervised visits and everything was good. She didn't want to do supervised visits. She just wanted to get around them. And then she came and served me with paperwork. And so I'm not 100% sure.
okay.
Your Honor,
Yes.
the state is involved in this matter, but I can clarify for that.
Okay.
We're on this docket because Judge Hahn and Judge Evans have both recused themselves from this matter.
Got it. That makes sense. I was not picking up on that recusal. And then Ms. Turnbull, I know you also have been involved in this matter, and I'm looking back to Judge Evans' April 17th order, where Mr. Ruby was awarded primary custody. There was supervised visitation given to respondent, and then the GAL was appointed. Subsequently, now we have a motion for temporary orders that certainly changes that playing field and is alleging several deficiencies on the behalf on petitioner. I guess, Ms. Turnbull, what input can you give the court at this time?
Well, the concern last spring, I believe, has largely been remedied. Ms. Granzo Carranza was actively using drugs and had a suicide attempt. She did have a dependency case that was filed, and the two youngest children were removed from her care. One was placed in foster care. The second child was placed with Mr. Ruby and his wife. And Ms. Granzo Carranza has since entered drug court. She, as you see with her UAs and the other documentation that she's filed, she is actively in treatment and is sober. She has been for several months now. She is doing quite well. The dependency case has been dropped. She has her youngest child back in her care, and she would like to have Livea back in her care as well. I think that Mr. Ruby and his wife have some concerns given the history about letting Livea go back with Ms. Carranza, but they haven't put that in writing. So that I have seen. So that's where we are. She is doing much better at this time.
And I guess just procedurally, is this a case where really since 2022, you all have just been operating under temporary orders? There's never been any final parenting plan order issued?
Correct.
Okay.
Yes.
I just want to make sure I wasn't missing something, because typically with a case that has this 2022 history, we'd be talking about adequate cause findings to readdress, but I'm not showing at any point where there's ever been finality of your parenting plan orders.
That's correct.
Okay. And so up until Judge Evans' April 17, 2024 order requiring supervised visitation, what did visitation and residency for the child look like?
So the last few years, the girls have gone back and forth between me and Marcus. It's been a little bit of a struggle. They'll live with me, and I take them to visit dad. Like every 6 months, I'm going to be 100% completely honest, they bounce back and forth. That had a lot to do with my addiction and my active use and whatnot. It's like I told Ms. Turnbull the other day, there's going to be a lot that needs to be done in regards to me and my older two. In regards to like family counseling and whatnot. And I would love to get that started. I just can't do anything about it until I can establish some sort of visitation. Back in April, Judge Evans requested supervised visits. 2 days after that, I attempted suicide, and the younger two were removed from my care. I was stuck on the 3rd floor in the hospital, was there for about 72 hours, was released, and by the time I got out of the hospital, my youngest, my 1-year-old, was placed in foster care, and Lavea had been placed with Marcus. Prior to that, Lavea hasn't been involved in any of these court matters since 2022. It's only been Bethany and Anna. Up until April, Marcus had nothing to do with Lavea, which is why I'm asking for the return of Lavea, because I have been the only home and the only parent that she knows. I've asked for my visits with the girls. I have not asked for all 3 of them to be returned home just yet, because I feel like that would be a lot on my plate considering the recent, the recovery time. I have 84 days today. I'd like my youngest with Marcus to be returned home. Had CPS not placed her with Marcus, I would already have her back. CPS dismissed our case September 19th. And I'm not trying to take Lavea away from Marcus by no means. In the temporary orders, I asked for Lavea to be returned home to me full time, and visits with my older two on the weekends. Every other weekend, on the weekends that Marcus has Bethany and Anna, he is able to have Lavea. I'm not trying to take her completely away from him at all. I mean, it is her dad. Whether he's been active in her life up until recently, that's, it's still her father. So, I tried to, when I did the temporary orders this time around, I went in to go motion the court to change it, and had found out there was no final order done, which is where this temporary order comes into play.
And I'm just looking to see, and maybe I'm missing it. Hold on. So Ms. Turnbull, I know I had received your original review and recommendation, which did support removal from Ms. Carranzo's custody at the time there was active use going on. Is there an update I'm missing, or are you able to give that update today on your opinion of what visitation should look like at this time?
Sure. I think it's reasonable to have visitation. I think given Ms. Carranza is still fairly newly sober, and I don't know that it's necessarily great to put Livea 100% back in her care, but it's reasonable to give her some time with Livea. And so whether that's weekends or, a 2-2-5 plan, something along those lines.
Mr. Ruby, what is your position on unsupervised visitation at this time? I do have quite a series of negative UAs over the last several weeks and months.
Yeah, so I'm okay with supervised visits at this time. Once she can prove that she can keep up with the clean UAs and everything like that, then we can transition into unsupervised visits. But like I said, at this time, I think it'd be better for supervised. That way, because I don't want to put them through more stress if it's not needed. But I know the girls want to see their mom.
What's your position on unsupervised visitation? That's what I'm asking.
Not really comfortable with that yet. Just because Livea just got comfortable with me. She's opened up. She's an outgoing little girl, and I don't want to see that get turned around in any way.
Are they in any sort of counseling?
Yes.
I was gonna bring that up.
Yeah.
When I spoke with Mr. Ruby's partner, Brooke, just this week, she had missed an appointment and they hadn't actually gotten started with counseling. I did speak with Ellen Wynn, who's the school counselor at Olympic, where the girls are in school, and they have the opportunity to have counseling in school if a parent will come in and do the intake, which will take about an hour. And so I'm hoping today we can arrange to have one of the parents go in and do that. Ms. Wynn will make the referral. We could get both Anna and Bethany in counseling at school so that the parents aren't having to transport them. I know that Mr. Ruby and Brooke have a lot of children in their home, and that's difficult to do that transportation. But I do believe the children need that counseling.
And this is the first I'm hearing of the school counseling part of it, so I'm more than willing to do that.
Okay.
And I can get a hold of my wife and have her go down and do that today.
None at all. Before Beth and Anna went and lived with Marcus, Bethany was actually engaged at Climate Elementary with counseling there.
Okay.
And from my understanding, has not been engaged since. So she would really benefit from the counseling. Anna as well.
Okay. And then I know Ms. Turnbull, I think if I read the July report correctly, that kind of ended your kind of initial assignment to the case. My hope, and I'm going to make some changes here, but my hope is before we actually do orders that I could reappoint you to re-engage in this investigation process. Because I'll just note specifically too, now there does seem to be allegations. Ms. Carranza is proposing that this court find several 3B factors by Mr. Ruby, including neglect, substance abuse, lack of emotional ties, use of conflict, withholding the child. So quite a few limitations she's proposing against him. Because here's my thought, and I know this is a very long-worded question to you on reappointment, but I am going to issue an order that allows unsupervised visitation. I do think that Ms. Carranza has proven to this court that she is entitled to that and that the children are safe doing so. So I am going to do that through a bench order at this time that amends the prior order Judge Evans put into place. We'll talk about when those visits make sense. That order is also going to include a mandate that the girls, and is it all 3 girls were still, all 3 children? Because your proposal has Bethany, Anna, and Lavea listed.
So I'm at, like I said, I was asking for the return home of Lavea just because of I'm fresh in recovery, you know, and to ask for all 3 to be returned home, I feel like would just be setting myself up for failure.
Okay.
And I'm not at all trying to do that. Upon return home, if any, I do plan on getting back involved with CPS and doing family voluntary services.
Okay.
Yes, my case with my youngest was dismissed, but they've offered and are willing to still support me. And upon return home, I'm 100% for that because of everything that did take place back in April.
So
there's a lot that went on that went against me, and all I'm trying to do is prove that that's not who I am anymore.
So with the visitation right now, so I'm not changing the primary home today.
Okay.
I mean, I'm going to see if Ms. Turnbull's willing to be reappointed. I know she's never really been discharged, but reappointed kind of back at our normal 22 hours, et cetera, because you probably hit a cap in your original investigation. But reappointing her so the county will pay for that further investigation, make a recommendation to the court about what this should look like. But for now, if we're doing unsupervised visitation, is the request for all 3 girls to be part of that?
Yes, please.
Okay. So, Ms. Turnbull, before I go further and talk about what that looks like, would you be willing to have the court sign an order and if reappointing you to start this process over, given kind of the new landscape of where we're at?
Yes.
Okay. I do
have a question.
Go ahead.
If she does get her visitations, can we set it to where it's just her and the kids and like not her friends and everybody else included? That way it's just them and the one-on-one time.
Yeah, tell me what the concern is and I will be happy to address that.
So I just want to make sure that it's between them, because I know when they were in Sam's care last time, she would always pawn them off on her friends so she can go hang out with other people on the weekends. And so I just want to make sure that it's just going to be her and her kids.
Let me just
that
check.
way they get that time that they have.
Okay, just to check in. So where you currently live, do you have roommates, other people around?
I live on my own in Clam. I'm housed through Kelso Housing Authority and I live alone.
Okay.
I honestly have no friends. I have a sponsor. I go to the 1414 club all the time. If I'm not at home, I'm at the 1414 club or I'm in treatment.
Okay. So if there was, just for sake of making everyone feel comfortable with how this goes temporarily in my bench order, if we were to say unsupervised visitation at your home, however, no adults should be there who are not agreed to by the parties or otherwise approved by the court. Would that work for you?
Yes, I do have a question though.
Okay.
In regards to that, because up until April, Marcus hasn't been a part of Levea's life, and she knows one other man as her father, and that's Raina's dad. And he would like to see Levea too.
Okay.
I completely
let's just
understand.
baby step this in.
Yes,
because a lot of times what I'll want from the GAL that I'm now reappointing is we will look into the backgrounds of other significant others or adults who may be around the kids.
Okay.
That is a very common part of what we'll do. So just temporarily at this point, while you guys are getting to know each other, I do think it makes sense that it's just the 4 of you.
Oh no, absolutely.
Okay.
Absolutely. I completely agree to that.
Okay.
In regards to that part though, I'm totally okay with that. Would it be okay to do a video call, or do you want me to hold off on that? So no other adults with me while I have the children. I completely understand that, but like a video like on Facebook or something.
Yeah. You mean when they're with him and not with you?
I mean, if he's willing to do the video calls, I mean that
here's what I'm trying to get at. So I'm giving you in person at your house visits. Let's start with that. When does that work for you? If I did weekends with you, Friday evening, to Sunday, 5 p.m. Does that work for you?
That works for me. I do have treatment from 5 to roughly 7:30 on Fridays.
Till when?
7:30.
So maybe Saturday mornings make more sense, because with a 2-year-old, that's kind of pushing it with moving
I
them
mean,
around?
it's just right there in Kelsoff Great Street, so I could have them picked up by like 7:45 and then go home if Marcus is to have him fed.
Okay.
I have no issue with that part.
Okay. Mr. Ruby, you haven't filed anything with me, so I don't really know your position, but why don't you let me know what you're thinking about visitation?
So that works for me. I was
Okay.
thinking on Sundays having home by like 3:30, 4:30 because dinner's around 5:30 to 6.
Okay. So would Fridays pick up at about 7:45 to 8 work for you then?
Yes, ma'am.
Okay. So what I'll do is put in the bench order Friday, 7:45 to 8, you pick up.
Okay.
And then you'll return them 3:30 to 4:30 on, so I'll give you that hour because I know things happen with juggling 3 children, especially a 2-year-old. So between 3:30 and 4:30, they'll be returned. And I like that because then they can kind of reacclimate to your house, Mr. Ruby, so they can get ready for school.
No, I completely
Okay.
understand that.
So we'll do this for now. We'll put in the order counseling, evaluations, and UAs. Oh, you brought up videos. While during the week, Mr. Ruby, I know with several children, it can get a little hectic. Do any of the kids have their own ability to video mom?
Yeah.
Okay.
I say we got both of the, so all of our older 4 kids all have their own like at-home cell phones now.
Okay.
So that way they can all talk to their friends at school and whatnot.
Okay.
So, but yeah, they definitely have a way to, if they needed to, get a hold of their mom or something.
Okay. Do you want there to be set times for video calls, or are you okay if the children decide when they want to video call mom?
Yeah, that's fine with me. I mean, like I said, Bethany has access to her own phone at all times. So does Anna. I'm
Okay.
just waiting on Anna's to come in because we ordered her one and it didn't work. So I had to send it back to get a new one. So I'm waiting for it to come in and she'll have her own as well.
Okay. So what I'm going to call this is video and telephone calls are allowed to mom while in residence with dad. I call it child led. So it's going to be at their discretion and choice.
Okay.
If when we come back, that needs to be further clarified. Some people have asked me for specific times, but it feels like the two of you are maybe willing to work to let the children decide when that needs to happen.
Yeah.
Okay.
Bethany's really responsible until I trust her with that decision.
Okay. Okay.
Your Honor, is this going to be every weekend or every other weekend?
So
right
now I have it as every weekend. Okay. Do you need
Nope. I'm okay with
something
every
different?
weekend.
Okay.
I am A-okay with that.
Okay.
I appreciate you.
Okay. So we're going to do this for now. Since I'm reappointing Ms. Turnbull, my thought is let's at least for now set a 30-day review date for kind of a status of how the new visitation plan is going and any information Ms. Turnbull may have on a preliminary basis. Why don't we set that for November? Let's do November 12th at 1:00. And then February 11, 2025 for what we would call our final GAL review or report date. Those will be our 2 set dates, November 12th, February 11th.
Okay.
If parties have issues that come up and you need to get that noted on, nothing precludes either one of you from filing motions and noting it on. Those are just going to be our 2 set dates as of today.
Okay.
Does that work for the parties?
Yeah.
Yes.
Okay, I'm going to do a bench order. It'll get signed after docket today. If you all want it, sometime later this week, you can grab it from the court. But
okay.
Mr. Ruby, are you okay with having those visitations start this coming Friday, or do you need additional time?
That's fine.
Okay, so this Friday will be our first, I'll just put the date in there so there's no confusion. October 4th is when that will begin.
Awesome.
Video visits can begin now.
Okay.
And can we clarify which parent will be going in to do the referral for the counseling?
Mr. Ruby, you will? Okay.
Yes. Me and my wife will.
Okay.
Because if I'm at work and I'm not able to get to it, she will be at home and be able to do it. So.
Okay. And then what I'm going to do is hold off on your temporary order. We're just going to have this bench order in place until we get a little more feedback from the GAL, and then we can talk about orders at that point. Okay.
Sounds good to me. Thank you,
Okay.
Your Honor.
Okay, Mr. Ruby, anything from you?
Nope, that's it for me.
Okay, thank you both for working together on this. I appreciate it.
Thank you.
Thank you.
Have a good day.
I'll take it back just to keep it for
Okay.
for
To work off of next time.
yeah.
Okay, thank you.
Oh, thank you. I appreciate it.
Okay, nope.
All
All right,
Okay.
and then,
Sounds
Do I have Mr. Hill, or is he planning to
I
be
do
here?
not anticipate him being present.
Okay.
Judge.
Okay, go ahead, Ms. Bliss.
Thank you, Your Honor. We're before the court today on a presentation. This was in front of Judge Basher, so depending on Ms. Hill's position on this order, it may
Okay.
need to be back in front of him. However, we had a hearing back in June. Ms. Hill at the time was represented by Ms. Roberts. I believe it was a motion for contempt. Within that motion, it was related to drug testing provisions. Commissioner Busby, way back when, I believe it was in 2019, entered a bench order, a handwritten bench order that said standard, I'm paraphrasing at this point, but standard drug testing provisions shall apply. And then that was the entirety of it. Obviously, as attorneys do, we interpret it one way, others interpret it others. So at that contempt hearing, Judge Basher had indicated it would be best for the file and best for these parties moving forward if we clarified that language. I agree. I attempted to have this order entered prior to Ms. Roberts withdrawing. However, she has since withdrawn. I did send this to Ms. Hill in hopes again that we could get this entered and signed ex parte. Again, I did not receive any sort of objections or any sort of response from her on this. So I don't know her position. If she is agreeable to the language, which I would just note as an officer of the court is very standard language that I typically include in all of my cases where there is testing provisions. If she does not have any objection, I would ask that that be entered today. There is one scrivener's error on that first page. Again, I did prepare this when Ms. Roberts was representing Ms. Hill, so it does say that she's appearing today through her attorney, Ms. Roberts. I would just ask if the court does enter that today, that you strike that and just kind of interlineate that she's appearing per se.
Okay. All right. Ms. Hill, have you had a chance to review? And I know it sounds like this is an issue where there was an attorney and previously, have you had a chance to review Ms. Bliss's proposed language regarding the outcome of that June 18th hearing?
About the drug test?
Right, to clarify that 20.
Yeah, I thought I already signed paperwork okaying the order.
Okay. We haven't seen it, but let me just read it to you just to make sure. I'll ask if you agree or disagree, okay? So it says, this matter has come before the court on respondent's motion, respondent Jonathan Hill being represented by and through and his attorney Carly Bliss and petitioner Jamie Hill, and I'm just going to cross this out and say pro se. And the court being fully advised, now therefore it is hereby ordered, adjudged, and decreed the December 9, 2021 bench order entered in this matter is hereby clarified to include the following. Mother shall refrain from using or consuming any non-prescribed medication, legal or illegal substances during the pendency of this case. If at any time father suspects mother is under the influence or using substances, he may request a urinalysis, blood test, or hair follicle test be completed at father's expense within 4 hours of the request. In the event mother is at work, she must provide proof of her schedule and submit to testing as soon as her shift ends. Failure to submit to testing or a positive result shall result in visitation being suspended pending further order of the court. If mother's results are positive or she refuses to complete the test, mother shall reimburse father the cost of the test within 48 hours. Previous orders in this matter not affected by this order shall remain in full force and effect. Do you agree with that language from the June?
Yeah, I agreed to it. I do.
Okay. I am going to go ahead and sign, and I'm just going to note approved via Zoom on your signature line. Okay. there anything else we need to do on this today?
No, Judge, that was all that we were before you for.
Okay, I'll go ahead and hand that to the clerk. Ms. Hill, thank you for, I almost said Ms. Cost.
That's okay, sorry.
You're fine. Thank you for being here. You're free to log out.
Okay, thank you. And you have
Yes.
a nice day.
You too.
Thank you. Bye.
Thank you. I saw Ms. McLean maybe log back in. Did we need to do something else?
Looks like that's just her staff.
Okay. Just checking in. So let me just check in. Is anyone else here thinking they have a case on this docket? I have run out of matters. Okay, I'm going to go ahead and end docket.